Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law. Please subscribe to our channel. One of the questions we were asked is if I find out that the other person's involved in drug use, can I immediately suspend the parenting time? Can I keep my child from the other person, even if I have yet to get a court order? Well, it's a very good question. There are two aspects to it. There's what you should do and what you're allowed to do. Are you allowed to suspend parenting time on your own without a court order? Lawyers will tell you, no, you got a problem, you go to a judge. You don't stand in the judge's shoes. You tell the court what the problem is. You let them suspend the parenting time. I mean, clearly that's the appropriate sentiment. The decision about to suspend or not to suspend is something that the court considers is something that, could be something subject to abuse. A parent could say, I suspect drug use, when they don't really suspect drug use, and use that as an excuse to just, spontaneously suspend parenting time. The court doesn't go for that. Therefore, the court's preference is you file an emergency motion. You tell the court immediately that there's this problem, that here's the proof that this person's on drugs. Here's a picture of the person using cocaine, which he, in a fit of horrible misjudgment, posted online, and that's how you know about it. So you bring it to the court's attention, the court issues an order, then you're protected. But that's a different analysis. The question now is, what if we don't have time to get the order? We just found out. We know what we're supposed to do is follow the judge's order. As a practical matter, what do? Do we send our kid there or not? Well, if you are persuaded that it's not just you assuming something, if you have evidence that the other person's on drugs, or they show up for a pickup and they reek of alcohol, or they smell like weed, and you can tell that they're stumbling, their eyes are blurred, you're not sending your child into a car with that person. No way. You take the chance that if they file a motion and they say she denied me my parent time, you can take the chance and tell the judge, here's the reason why. This guy was stumbling around, this guy was drunk, here's a video of him, here's what I saw, and you know what, judge, if I did the wrong thing, I did the wrong thing, but it was only because I needed to protect my kid. If that's the situation, lawyers are always going to tell you to follow the order, but if you as a parent feel that the humanity of it is such that the order is one thing, but you can't possibly send your kid into that dangerous situation, do it. Do what you got to do. You'll have to explain yourself, there's no question about it, but if you can support what really happened, like you have a witness who saw it, who can come to court, or you did a video and you can see the guy stumbling back into his car, that kind of thing will go a long way in having the court say, you did the wrong thing because you should have come to me, but I'm not going to sanction you for it because I see why you did it. You're in a better position to do that. Most lawyers will tell you, though, it's always better to ask for permission than forgiveness. But sometimes, where that analysis ends, your sense of protecting your child, that has to pick up. And sometimes you've got to make that choice. If you have questions about that choice, reach out, and of course, we'll be glad to help you out.